Hello everyone, today we'll be exploring the appellate jurisdiction of high courts and the Supreme Court in India. This presentation provides an introduction to what appellate jurisdiction means, specifically detailing the processes and constitutional provisions governing appeals in India. An appeal, at its core, is a process where a person or party challenges the correctness of a court's decision before a superior court. In our discussion today, it primarily refers to challenging a high court decision before the Supreme Court. The Supreme Court was conceived by our Constitution makers as a court of rarity, meaning only genuine or truly deserving cases should reach it for adjudication. The way to approach the Supreme Court is designed to be quite challenging, yet it's interesting to note that the majority of cases heard by the Supreme Court actually arrive via this appellate process. First, let's look at appeals before the high courts concerning civil matters. There are several types of civil appeals, including regular appeals, which are often a right, revision petitions, and second appeals, which typically have specific pecuniary thresholds. The general scope and grounds for these appeals often revolve around jurisdictional errors, misapplication of law, or instances of grave injustice. The general procedure involves specific filing windows, a process of certification, sending an advance copy to the opposing party, requisitioning the court record, and finally, setting hearing dates. Moving on to criminal matters before the high courts, the types of appeals include appeals from sessions or magistrates' courts, bail revisions, and criminal appeals on high sentence orders. Similar to civil matters, the general scope and grounds for appeal typically involve jurisdictional errors, misapplication of law, or situations leading to grave injustice. The general procedure also follows a similar pattern to civil appeals, encompassing filing windows, certification, serving advance copies, record requisition, and scheduling hearing dates. Now, let's turn our attention to appeals before the Supreme Court. There are primary ways to challenge a high court decision through appeal. First, on the basis of a certificate of fitness granted by the high court itself. Second, through compulsory appeal in certain capital cases. And third, by special leave granted by the Supreme Court itself. These methods are rooted in specific constitutional provisions, notably Articles 132, 133, 134, and 136. Beyond these, there are also statutory appeals, for instance, under the Insolvency and Bankruptcy Code, references from high courts, and direct access for fundamental right cases under Article 32. Let's dive deeper into appeals based on a certificate of fitness from the High Court. Article 132 allows the High Court to grant a certificate of fitness if the matter involves a substantial question of law regarding the interpretation of the Constitution. This applies to both criminal and civil cases. If the High Court grants this certificate, the Supreme Court is then duty-bound to hear the appeal. Article 133 is confined solely to civil matters. Here, a High Court can grant a certificate of fitness if it finds a substantial question of law of general importance is involved. For example, a complex interpretation of contractual terms among private parties. As with Article 132, if certified, the Supreme Court is duty-bound to hear the appeal. Finally, Article 134 covers criminal matters. In any criminal case, if the High Court is of the opinion that the matter is fit to be heard by the Supreme Court, it can grant a certificate, and the Supreme Court will be duty-bound to hear the appeal. Lastly, let's look at compulsory appeals to the Supreme Court in capital cases, as covered by Article 134. This method is strictly confined to capital cases where a death punishment has been awarded. There are two specific scenarios. First, if a trial court, like a sessions court, acquits a person, but the prosecution appeals to the High Court, and the High Court then reverses that acquittal and awards a death sentence. In such a situation, the convicted person has a compulsory and indivisible right to approach the Supreme Court. The second scenario is when the High Court withdraws a criminal case from a lower court, such as a sessions or district court, hears the matter itself, and directly pronounces a death punishment without giving an opportunity to the lower court to decide. In this instance, the person can directly appeal to the Supreme Court over this decision. Thank you for listening. Hello, everyone.